President Donald Trump on Wednesday urged the Supreme Court to take up the dispute over his emergency tariffs, placing the centerpiece of his economic agenda in the hands of justices who have mostly supported his broad view of executive power. According to a copy of the appeal obtained by CNN, Trump is asking the justices to overturn a lower court ruling that found his administration acted unlawfully by imposing many of his sweeping import taxes, and he has framed the case as critical for the country.
The stock market needs the tariffs. They want the tariffs, Trump said Tuesday in the Oval Office, warning that an adverse decision would mean devastation for our country. The case again raises key questions for the court about a president's power to act unilaterally without explicit approval from Congress. Trump's critics note that the last president to raise tariffs under similar circumstances was Richard Nixon, and Congress later cut back presidential authority. To the president and his most senior advisors, these tariffs present a clear choice. With tariffs, we are a rich nation. Without tariffs, we are a poor nation, the appeal states. The appeal follows a split decision Friday from a federal appeals court in Washington that found Trump exceeded his authority by using the International Emergency Economic Powers Act to impose tariffs. The court ruled that the power to impose taxes, including tariffs, is a core congressional power given by the Constitution to the legislative branch. Trump has relied on the 1970s-era emergency law, known as UEPA, not only to reshape global trade but also to manage relations with allies and rivals. If some of the powers he has claimed to set tariffs are permanently blocked, the administration would need to find other ways to advance its foreign policy goals. At the center of the case are the Liberation Day tariffs Trump announced in April, and tariffs placed this year on China, Mexico, and Canada, which were aimed at fighting fentanyl entering the United States. A wine importer, VOS Selections, and other small businesses, along with a dozen states, sued, arguing that Trump exceeded his authority. Both federal courts that considered the issue agreed that IEEPA does not give the president unlimited tariff authority, said Jeffrey Schwab, senior counsel and director of litigation for the Liberty Justice Center, which represents the plaintiffs. These unlawful tariffs are inflicting serious harm on small businesses and threatening their survival. We hope for a quick resolution of this case for our clients. The Trump administration has asked for an unusually fast review by the Supreme Court, requesting that the justices decide by September 10th whether to hear the case and schedule arguments for early November. The plaintiffs agreed to that timeline. A federal court in New York had sided with the companies and states in May, and the U.S. Court of Appeals for the Federal Circuit upheld that decision, though it allowed the tariffs to remain in place temporarily. During the litigation, the Trump administration told the Supreme Court that the lower court's ruling would, in the president's view, unilaterally disarm the United States and allow other nations to hold America's economy hostage to their retaliatory trade policies. While many of the tariffs Trump imposed in his second term under emergency economic powers could eventually be ruled illegal, the president still has other tools to pursue his tariff-heavy agenda. Trump has not only used IEEPA to impose tariffs, but also Section 232 of the Trade Expansion Act of 1962, which allows the president to levy tariffs on national security grounds. For example, he recently imposed a 50% tariff on steel and aluminum derivatives such as spray deodorants and baby strollers. However, Section 232 only applies to specific sectors and requires an investigation before tariffs can be imposed. Trump also has other methods to apply tariffs that are not under legal challenge, though they carry restrictions that could limit his ability to use them as bargaining tools as quickly as he has since retaking office in January. This ongoing case is not the first to reach the Supreme Court regarding Trump's emergency tariffs. Two American family-owned toy companies filed a similar appeal in June, and the court is scheduled to meet later this month to decide whether to hear that case. The broader legal fight could involve the major questions doctrine, a theory conservative groups have used at the Supreme Court in recent years to block former President Joe Biden's agenda, including his plan to forgive student loans. That doctrine has been applied to limit the White House and federal agencies from acting without Congress. The law in question allows a president to regulate importation during emergencies, but it does not specifically mention tariffs. The law grants significant authority to the president to take a number of actions in response to a national emergency, the appeals court wrote, but none of these actions explicitly include the power to impose tariffs, duties, or taxes. Record levels of tariff revenue have flowed into the U.S. Treasury since Trump raised tariffs in the spring, with more than $210 billion in fiscal year 2025 tied to IEEPA-related tariffs, according to U.S. Customs and Border Protection. If the Supreme Court refuses to hear the appeal or sides with the lower courts, American importers could be owed refunds. Trump admitted that possibility this week, noting that the case could also affect ongoing trade agreements. Many of the trade deals I made were because of tariffs. They give you great negotiating power, Trump said Tuesday, but those agreements could fall apart if his authority under IEEPA is struck down, as other countries may push for better terms knowing his ability to impose tariffs is weakened.